I welcome the opportunity to contribute to the debate today on the Social Welfare and Pensions Bill 2014, which makes some changes, and some of them I think could have far-reaching implications for some people dependent on social welfare. And when I'm talking, I'm just going to cover three aspects of it, basically the self-employed, the HRC, and the family income supplement. But I think I have to comment, I wasn't going to address it in my contribution today in relation to changes in relation to fraud and fraud detection within the bill as well. But it always interests me that particularly the Fine Gael deputies, when they contribute on social welfare bills, always bring up the issue of fraud, and that fraud has to be dealt with, and that. And the only thing that fraud that I can see within the Social Welfare Code has going for it is makes nice, sexy, attractive headlines in the papers when somebody is caught defrauding the system. But when you look at the actual figures for fraud within the social welfare system, and these are figures from the department's own website, in 2010, fraud represented 0.4% of the total revenue expenditure by the department. 0.4%. And then in the department's own studies in relation to particular benefits and payments and the fraud elements of them, we see in job seekers study done, I think it was in 2012, that they detected 1.6% of expenditure was through fraud. But they also actually detected that 1.5% of expenditure was done by administrative error, which is very similar. And then disability allowance, they detected 1.2% of expenditure through fraud and 0.9% of expenditure through administrative error again. So I just wanted to put it in some perspective and some context in terms of social welfare fraud, of how much of an issue it actually is. And if we look even for 2014, I think the department's target figures, and it's interesting that they always put fraud target figures along with administrative error figures, so that makes it look even more shocking than it might actually be. But the department has targeted 700 million in either savings, which is probably what it is, rather than recovery of money, which represents about 3.5% of the entire social welfare budget. And if you look at the studies that the department has done in relation to it, you could estimate that probably about 1.8, or half of that, 1.75%, will relate to administrative errors rather than actual fraud. So we're really talking about less than 2% of the overall social welfare budget when we talk about fraud. And I just wonder about the amount of time and energy that's put into detecting it. And obviously fraud has to be detected, and nobody's going to condone somebody who actually is defrauding the system. But by focusing too much on fraud, we're putting out the image there that everybody in receipt of social welfare is actually a potential fraudster and a person who's actually taken something that they're not entitled to. So I just wanted to address that in the initial contribution. In relation to the self-employed people and the transposition of the Directive 2010/41 of the EU, extending the social PRSI cover to spouses and certain people related to self-employed people. I think this is welcome, and it's interesting that it's European law that's making it happen here, but I think it doesn't go anywhere near far enough in terms of self-employed people. And I've listened to other deputies talking about how it's important that we should, and this is a great progressive step, that we're extending social welfare coverage to self-employed, the spouses of self-employed people, but all we're actually doing is allowing them to avail of a contributory old age pension when they reach the age of 66 or 68, as the case may be, in the years to come. There is actually no benefit accruable to people who start up businesses, who maybe end up their businesses folding. They have no safety net, and there's no provision made for them there. And some deputies have mentioned that a voluntary system is the way to go in terms of extending cover for self-employed people, and that we should try it out on a voluntary basis first and then see how that works over the coming years. But there is already a voluntary system in place within the PRSI system. It's a Class P contribution, I think, for share fishermen, and it's voluntary. They make a voluntary additional payment, which entitles them to 13 weeks, I think it is, job seekers benefit annually, and gives them other provisions and other cover. In order to avail of that, they have to make an extra 3% contribution on their gross income, which is a voluntary payment, as I've said. And it's interesting when you look, I think there's something in the region of about 1,400 share fishermen in the country, and the figures for actually people who avail of these voluntary contributions is around about 16. So about 16, somewhere under 20 fishermen every year that this system has been in place have actually availed of it. And the problem with that is it's because it's a voluntary scheme. So I don't think that any voluntary scheme being put in place for self-employed people will actually have the desired effect. And I think it'll be a waste of time, basically, because nobody voluntarily is going to pay tax. Nobody wants to give over their income. And if you're working and you're doing reasonably well, or you're doing okay and you're making a living, you don't want to have to voluntarily give up another 3%, because it's an abstract thing about what if something goes wrong. So it has to be, if there's going to be any changes, it has to be a compulsory scheme, and I don't see any other way that that can work. And I've raised this on a number of occasions with the Minister, and unfortunately we keep getting trotted out the same old thing about that self-employed people benefit far more actuarially out of their contributions than employed people do, and that self-employed people pay so much less and everything else, and these are all the reasons for not doing it. But actually, if it was made compulsory with an increased payment and an increased contribution from the self-employed people, and as Deputy Penrose outlined earlier, you have to, for all benefits within the social welfare system, you have to have a qualifying period where you're making contributions before you're entitled to benefit from that. So it actually would bring money into the social insurance fund for probably, if you look at equivalent to job seekers benefit, for 2 years before there would actually be any drawdown on it. So it actually would help with the balance in terms of the social welfare fund or social insurance fund if it was actually implemented in that way. I drafted legislation and tried to publish legislation to implement a system of compulsory contributions for self-employed people, but unfortunately, because of this rule in this House, the Ceann Comhairle's office ruled it out of order and it couldn't be published because opposition deputies can't introduce legislation that could have a cost on the Exchequer. So unfortunately we haven't been able to debate legislation or debate the potential for any legislation in this House because of those reasons. In relation to the habitual residence condition, I see the changes that have been made within the bill is that the presumption regarding the continuous residence for 2 years prior to making an application is being removed. And on the face of it, you'd probably welcome that, and I would welcome it myself, because I know from dealing with HRC that it is extremely difficult for genuine applicants to actually satisfy the condition. And it's because of I believe, because the arbitrary nature of decisions being made by department officials in relation to HRC. There are 5 factors that are supposed to be being given consideration. I've seen reports, inspectors' reports and deciding officers' reports that haven't taken into account the 5 factors. Maybe made a decision on HRC based on 1 or 2 of them, and refused somebody a payment who they're desperately in need of and need that protection on the basis of not even looking and examining the case properly. Now, maybe it might be an unintended consequence, but will it be a consequence of the removal of the 2 years continuous residence condition give an open-ended view to department officials to look at people's, what do they call it, the habitual residence and their centre of economic activity or their centre of economic interest. So does it open it up and give it open-ended? And we look then at the future intentions of the applicant as well. So that allows, I believe, will allow for even more arbitrary decisions to be made within the HRC condition that will actually penalise people who are entitled to a social welfare payment and should be receiving a social welfare payment. And I know that the reason given by the department and for bringing this in the legislation is that it relates mainly to people who have work visas who are here and their visa expires, so therefore they're not entitled to be in the state anyway, so they shouldn't be entitled to a social welfare payment. But I just wonder, and the danger is how these things will actually be worked out in the future when this legislation is changed. And I think that the way the habitual residence condition has been examined and been looked at and been decided on at the moment is flawed. And I think that this change will actually increase that and will increase hardship for very many people. Just finally, last thing, Corley, just in relation to the family income supplement changes, and I know the bill proposes that if a family has received a family income supplement and their situation changes, for example, they lose their job or whatever, that the payment stops, which is fair enough. but that the payment will stay for 52 weeks. So in a situation where somebody is working and receives a family income supplement and a decision is made granting them family income supplement, they lose their job, and then maybe, if they're lucky enough, very quickly again get another job, more than likely will be at lower wages. The family income supplement cannot be reviewed. There cannot be any change. It will stay in for 52 weeks. So that is actually going to penalise families even more, I believe, and it could lead to a situation where people wouldn't be able to take up a job, or wouldn't be in their interest to look for work, because they're going to be penalised on the basis of a decision that was made previously. So I'm wondering, is that decision just made for ease of administrative purposes, or is there any actual rationale behind it, other than saving the department a few euro in terms of the administration of the system? Because that seems to me the only rationale for it.